Hello everybody, my name is Michael Quinn. I'm one of the directors of the Quinn Group. This week on Quintessential TV, we'll be discussing some of the legal issues facing buyers as they purchase a business. A business can be sold either on an enterprise or equity basis. An equity sale is associated with far greater risk than an enterprise sale, as acquiring the shares increases risk around contingent claims, particularly the Australian Tax Office, employee and consumer claims that may not be apparent at the time of the purchase. Buyers in such cases should seek to mitigate risk by undertaking extensive due diligence and obtaining warranties from the vendor. And we can help with this as we have a separate due diligence department. Therefore, it's no great surprise that most business sales are of the assets only, usually goodwill, intellectual property, plant and equipment, and that the buyer will either establish a new entity or merge the assets into an existing trading entity. This approach means the buyer is not exposed to the vendor entity's debts, actual or contingent. But in the case of a business sold by a liquidator, as shown now, employee entitlements can transmit to the buyer under some circumstances. Usually the buyer is oblivious to the added liability that is being assumed, and buyers should be aware of some of these risks. In a recent liquidation, the liquidator sold the intellectual property, goodwill and plant and equipment of a business to an industry competitor who acquired the assets in their existing trading entity. A formal sale agreement was entered into to effect this transaction. At the time, the buyer had not decided if they wanted to employ any of the vendor entity's former employees. Consequently, the sale agreement was silent on the employee position. Some weeks after the business sale settled, the buyer offered employment to a number of former vendor company employees in liquidation. Meanwhile, the former employees had lodged claims with the Fair Entitlements Guarantee, known as FEG, for their outstanding employee entitlements, which included long service leave. As part of FEG's adjudication process, it matched up some employees' current employer and requested a copy of the sale contract. Its review found the sale contract made no provision for the termination of employees and the assumption of employee claims by the vendor entity in liquidation. Notably, at the time of the sale contract being executed, the liquidator had already terminated the services of the employees. Accordingly, FEG rejected those employee claims for long service leave entitlements due to FEG deeming there to be a transfer of employment pursuant to a section of the Fair Work Act. FEG considered the fact that the old employer sold some or all of the business's assets, that is, plant equipment, intellectual property and goodwill, to the new employer to be grounds to establish there to be connection between the previous and the new employers. In circumstances where, as liquidator, sale proceeds were insufficient to discharge employee entitlements, the employers had to look to the buyer for their long service leave entitlements. This obviously came as a surprise to the buyer and was unhelpful to creating a positive relationship between the new employer and its employees. In advising a buyer on acquiring a business from a company in liquidation, it's critical to ensure that regardless of whether there is to be a transmission of employees or not, that the sale contract has specific clauses in the agreement which ensure that the buyer does not become liable for for any employee claims that are in the responsibility of the vendor entity in liquidation. If you'd like to know more about contract terms in a business sale transaction, or you need advice in this area, please contact us. You're welcome to email us at info@quinns.com.au. We'd love to get your feedback with relation to Quintessential TV, so please like, comment and subscribe. We look forward to seeing you all next week. I'm Michael Quinn. Bye for now.